It's 12 minutes past 9 Central African time. Welcome to Under the Radar here on Radio Islam International. Quite a strange story that we deal with right here on our doorstep here in South Africa. Not in our name, Eswatini activists are opposing shadow US deportation plans. And what exactly is going on here is that there is an agreement apparently between the Kingdom of Eswatini and the United States of America that resulted so far in 5 foreign nationals with no familial or legal ties to Eswatini being incarcerated in the Matsapa Maximum Correctional Facility following their deportation from the United States. The reports coming out in recent days that thousands of untracked U.S. planes are departing on a regular basis to third countries, and people who are deported on these flights have no links to the countries where they are being flown to, and their families have no information on where they are being sent to. Eswatini apparently is the first SADC country which has accepted one of these planes, and now this is being taken up legally. One of the applicants in this particular case is Melusi Simelane, who is the civil rights program manager at the Southern African Litigation Center, and is joining us this evening to explain to us exactly what is going on. Thank you so much for speaking to us this evening. Welcome to Radio Islam and good evening.
Good evening, Ibrahim, and thank you for having us.
A great pleasure. It might come as a great surprise. It's almost as if I don't know if this term would be suitable. It's been used in a different context, but almost rendition and notorious criminals. Sometimes we believe that are being sent to these different countries. What exactly is the agreement, and what exactly has happened so far?
Well, so far, what we know is that on July, and I believe it was around the 16th, a massive U.S. Air Force plane landed in the Kingdom of Eswatini, carrying what, according to the U.S. Homeland Security, was 5 individuals who had been convicted. And again, this is information that we are getting from the United States, that they had been convicted of heinous crimes, so heinous that even their home countries are said to had not wanted them back. So what the U.S. Department of Homeland Security said was that they then decided to send them to Eswatini because they did not want them on their shores. Now, during that very day, towards the end of the day, even, it was then the government spokesperson who came out on social media to sort of allay fears, to say, yes, indeed, the plane had landed, but Eswatini citizens had nothing to fear, because there was already a lot of conversation on social media during that day. And I think as days went on, the Prime Minister came out to then admit that indeed this plane had landed and indeed these people were being held in maximum security at Matsapa prison. But I think to sort of bring it back to why we are where we are today, it's because as civil society and as citizens in the country, we are finding ourselves at a crossroads where we've got a prime minister who has gotten into a deal with the United States by allowing the Kingdom of Eswatini to host these individuals who have no link to Eswatini, who have no familial or legal links to the country, to be brought in without any legal basis as far as we are concerned. And to have done that without consulting Parliament. So that is why we have approached the court to say the court must actually declare whatever deal was gotten into invalid for lacking constitutional rigor, because Parliament was never consulted.
What it entailed when this deal was struck, is it tied to any kind of financial support? And is Eswatini one of a number of countries that have entered into such agreements with the United States?
I think this is what we have been struggling to understand, Ibrahim, because you will understand that, of course, information that is available on media currently is that the U.S. is getting into these deals with numerous countries where the United States is paying up to like 4 million, 5 million for El Salvador as an example, and I believe it's like 5, or is it 4.5 million for Panama. but we do not know how much money was paid to the Kingdom of Eswatini. And I think for us as a country and as civil society working in the region, we have said we must not allow for Swaziland and we must not allow for the region to be used as a dumping site for unresolved issues of America. Because even if there was money exchanged, this is a conversation that should have been held in Parliament. And even if it was any sort of favor that the country is going to receive in the future, because we do not know what favor the country is receiving at the moment, this is a conversation that should have been dealt and addressed in Parliament, and the public should have been updated on this conversation. And currently, the government has withheld all of the details and all of the information, except to know that we've got individuals who are said to be dangerous being held in our prison facilities without any legal precedent or legal framework allowing it.
So the main argument or the main contentions that you are bringing up here, would it be, just the absolute absence of legality, the absolute absence of due process, or the threat potentially posed by, at the moment, these nameless individuals, which is the main line of argument or contention here?
I think that there's two ways to look at it, Ibrahim. You will remember that DECO in South Africa, the Department of International Relations, has already released a statement allaying fears to say that they are worried about issues of national security, particularly when it comes to immigration policies and immigration breaches that are potentially possible at this stage. And I think this is a concern that we have said as citizens and civil society. It's a concern that is correct, because you do know that as a region, our borders, having been drawn by colonial masters, have had an issue of being porous in some instances. So I think that is the one other security issue that has been sort of primarily in everyone's conversation about whether or not this could be a situation where people are being brought into country A and then they manage to get themselves into country B without the knowledge of the authorities of those countries. But I don't want for us to have a conversation about that at this moment, because for us, the concern is that there has been no due process, which is the second point that you raised on your question, the due process on how this deal was gotten into, number one, because the constitution of the country says that the head of government or the government itself, if it gets into any international agreement, be it a treaty, be it a bilateral or multilateral agreement, it must consult Parliament. It must get Parliament to ratify or to buy into it, particularly if this agreement has got financial, political, or serious ramifications for our region. And of course, now you've got a neighbor being South Africa. And you'll remember that Swaziland and South Africa are big trading partners. In fact, over 70% of the trade that Swaziland does goes through South Africa. So Eswatini cannot risk having a fractured relationship with South Africa by allowing such an agreement with the United States that has not gotten the buy-in of the Parliament of Eswatini. So the big issue here is the due process and the following of the Constitution and getting into an agreement that has the potential to upset the entire region.
Apologies for that. What I wanted to ask you as well is, you've highlighted the fact that within Swaziland and potentially Eswatini and other countries, there's a host of other local issues that these societies are dealing with, and particularly when one talks about the movement of quote-unquote criminals or notorious people and moving to security facilities. You speak about the overcrowding and the challenges within the correctional facilities already existing in places like Eswatini. Talk to us about that.
Well, as the Southern Africa Litigation Center, we have been working closely with SADC-PF. And I'm speaking to you right now, Ibrahim. I'm already at the SADC Summit, where we are joining other civil society players to have numerous conversations about how do we move the region forward. But for us, as a Southern Africa Litigation Center, we've been primarily working with the SADC Parliamentary Forum on how we can create model law that deals with prisons oversight, because our prisons in the region are overrun by a lot of people who are held in our prison facilities, whether it's overcrowding, whether it's individuals who are detained over and above the number of years that they're supposed to be there. Sometimes you find that in some countries, namely in Malawi, there will be people who are housed in our facilities without even the knowledge of the authorities, such that you lose people within the system. So our prisons are overcrowded and under-resourced and underfunded. In Eswatini, as an example, the Human Rights Commission had recently released a report working with the UNDP that the prisons in Eswatini are overcrowded and they're underfunded, which is not isolated to the country because, as I've said, the region has a problem with this issue. So now to have this deal where the Prime Minister gets to sign a deal with the United States without consulting Parliament to bring people to be housed in prison facilities that are underfunded and overcrowded, it begs the question as to whether or not this agreement that the Prime Minister has had with the United States is indeed going to benefit the Kingdom of Eswatini in accordance with Section 236 of our Constitution, which says every foreign policy position that the government must take must always be in line with the national interest. So it's a really big question as to whether or not we have the capacity to house these people. Another point to make here, Ibrahim, is that the facility that they are held in, which is the Matsapa prison, which is our maximum prison, the human rights report that we got recently from our Human Rights Commission in the country suggests that it's over 170% overcrowding in that prison alone. So then the question begs, what is the agreement that the Prime Minister has gotten into, number one? But number two, what are sort of the modalities that have been put in place to make sure that the people who are being held in these prisons, they're being held in accordance with the Mandela rules in terms of the UN minimum standards of the treatment of prisoners? Because you do not want people who are incarcerated to be treated inhumanely or to be tortured. But also over and above that, you will remember that these are people who would have served their time in the United States. So then the question begs, why are they back in prison in a third country called Eswatini without the parliament of this country having been granted their right to scrutinize this deal, to debate this deal, and therefore the public being informed and knowing exactly what is happening here?
And to talk to some of those points that you just made there, is this, then I think you have made that argument that this is an erosion of sovereignty. And if the United States in its immigration policy, works according to a particular standard, and that in itself is quite controversial in the United States among civil liberties groups itself, by sending these individuals to different countries, is there that expectation that those particular standards are upheld in exactly the same way? And that now poses a very deep challenge, and this could, from just a few random people being sent to a country, become the norm, to the danger of existing norms or existing legal standards within these countries.
You will remember, Ibrahim, that just recently we read in the news that the United States has struck yet another deal with Rwanda, who is said to receive up north of around 450 individuals. This is just something that we're hearing in the news. And I think, to your point around the human rights standards, it's well recorded that in the United States, as the origin of these people, there's already been a lot of fights within their court systems where people are approaching courts, arguing that the Trump administration, as they are sending these people out in hordes in large numbers to different countries, they are not following the due process, habeas corpus, for example, inside the United States, where people are granted the right to be heard, to actually even be given an opportunity to say they want to be sent back to those countries or not. So there's been a lot of human rights violations that we've been able to track all the way to the United States, even though we cannot opine on what is happening internally in the United States, but we can speak in terms of the region, and we can speak in terms of Eswatini as an individual country, but within the framework of SADC, to say we must not allow human rights violations that are happening in the global north to be replicated for us in the south. Because I think the bigger conversation here is that what we are seeing here is neocolonization, where we've moved from colonization to neocolonization, where we are now being forced to take these people because we are trying to gain favor, whether in terms of trade, as we know what has been happening right now with the tariffs. But we need to be able to reclaim our sovereignty, and we need to be able to reclaim our dignity as a people and say, we are going to follow the rule of law law, even if it means losing out on these trade agreements that are happening. And we're going to follow the rule of law because it's the right thing to do according to the African Charter on Human and People's Rights.
So lastly, relating to this litigation that has been filed at the High Court in Eswatini just in this past week, it was an urgent application. What is the status of it so far? When do you expect it to be heard, and what's your expectations?
So the matter was adjourned last Friday because it was filed on an urgent basis. So Justice Simelane was gracious enough to say it must come back to his chamber on Friday, the 22nd of August. So we are going back to court this Friday, where the Attorney General is going to make his case on behalf of the Prime Minister, the Minister of Home Affairs, the Minister of International Relations, and the Commissioner General of the Correctional Facilities. Because you'll remember, what we're asking the court to do here is to, number one, declare that this deal that the government got into is unconstitutional, but also to seek that the Commissioner General at the Correctional Services detail to us what sort of legal prescripts did she use to accommodate these people in prison, but also speaking to the Home Affairs Department to say what sort of law was followed in terms of the immigration laws of the country to allow the entry for these people, but also the International Relations Department to tell us how they got into this agreement with the United States without following Parliament. So we are looking forward to hearing what the court says on Friday, the 22nd.
Very important case to be following in terms of the precedent that it could set if it's not nipped in the bud or the clarity is not gained. Thank you so much for speaking to us, and we'll certainly watch the space. Melusi Simelane of the Southern African Litigation Center. Thank you so much for speaking to us on Radio Islam this evening.
Thank you, Ibrahim, and good evening to the listeners.